Hi, everyone. Welcome to today's webinar, part of our ongoing Board Basics series. The topic today is calling and conducting nonprofit board meetings. My name is Jason Q. I'm a managing attorney at the DC Bar Pro Bono Center in our nonprofit and small business legal assistance program. So just a little bit of housekeeping off the top. In your GoToWebinar client, you'll see a menu. On that menu, there's one tab called Handouts. If you open up that tab, you can download a PDF of today's slides if you'd like to follow along that way. Also, in the GoToWebinar client, you'll see a questions field. That'll allow you to type in questions throughout the presentation. And then at the end of the presentation, if we have time, I'll come and return to any questions that folks have asked. If I don't get to your question because of time issues, or if it's not something that we can, maybe it's too specific to talk about on the webinar, feel free to email me after the webinar with your question, and we can go back and forth over email for those folks who can't get their questions in on time. Okay, great. So let me give you a little bit more information about us at the DC Bar Pro Bono Center and our nonprofit legal assistance program. One thing that we do is that we match nonprofit organizations with pro bono legal counsel. The pro bono attorneys assist with a number of different ongoing legal matters, including corporate governance, IRS tax compliance, employment law, real estate matters. We call that our match program. We also host in-person one-day or half-day legal clinics to address specific issue areas. We have a clinic on shoring up your governance policies. We have one where we review your insurance. We have one where we review your intellectual property needs, your logos and potential trademarks, stuff like that. They're great. We sponsor trainings, webinars, and podcasts, such as today's event. And we provide written resources, guidebooks, and archive training sessions on our website. That website is www.lawhelp.org/dc/CED. And as I mentioned, today's webinar is part of our ongoing Board Basics series, where we talk about real-world, day-to-day operational and managerial aspects of running a nonprofit board. Other topics in the Board Basics series include how to take minutes, how to vote and take other board actions, how to meet an executive session, forming and using executive committees, forming and using board committees or advisory committees, and managing conflicts of interest within your board. So I would definitely recommend that folks check out the other webinars in the series, and especially for today's presentation, there's going to be some overlap with some of the other topics that we've done, especially board voting, executive session, executive committees. So if you want to go kind of in depth into those topics after we talk about them today, just know that we have webinars on the website about those topics. So about today's webinar, we're going to cover the rules and best practices with respect to board meetings for DC nonprofits. The topics will include how often should you hold board meetings, who can call a meeting, do you have to give notice, and how do you give notice? Do you have to hold open meetings, or can you have closed meetings? How do you prepare for board meetings, and what are some best practices for conducting a board meeting? One thing I want to highlight here is that the focus will be on DC-based organizations. That's because some of the specific rules and requirements emanate from DC law or state law. Specifically in our case, it's the DC Nonprofit Code. So we're going to be diving into those DC code requirements. If you're listening and you're from a non-DC incorporated organization, I think today's webinar could still be useful for helping you issue spot and sort of map out considerations that you should take home and think about within your organization. But just know that the specific legal requirements we're going to be talking about might not apply to your organization, and that you should definitely check your state nonprofit code or equivalent law to see what those specific requirements are. So if I say that the nonprofit code requires 2 days of notice, just flag that that might not be the standard in your state. Oh, another thing I want to flag is that our webinar does not cover membership meetings. We're only going to talk about board meetings. So if your nonprofit has members, additional requirements will apply to your membership meetings. A little bit of background about what that means for those who don't know. Nonprofit organizations can have what are called members, and we use that term in a specific legal sense. So under the DC Nonprofit Code, a member is an individual who has recognized and enforceable legal rights over the governance and the management of a nonprofit organization, similar to how shareholders work in the for-profit context. So a nonprofit member in this legal sense is able to elect members onto the board of directors. They're able to approve major corporate transactions, and they're able to attend membership meetings where they get to kind of participate in the governance of the organization. If your organization does not have members, then all of those functions are just performed by the board of directors itself. Nowadays, it's much more common for organizations to not have members. So if you have any questions about whether or not your organization is a membership organization, you should check your articles and bylaws. I'll just want to flag that here because if you do have members, membership meetings have very specific notice and conduct requirements that are outside the scope of today's webinar. And the final kind of disclaimer or setup piece that I want to note is that your governing documents, when it comes to holding and conducting board meetings, tend to control the situation. So the DC Nonprofit Code contains default provisions regarding how nonprofits should call and conduct their board meetings. If your bylaws are silent on these issues, then the Nonprofit Code's default rules apply. However, the code will often allow nonprofits to adopt alternative rules in their articles and bylaws. And I'll generally note when you have this kind of flexibility. Sometimes the code will have certain limitations or thresholds against what you can do, but often the code will give you some flexibility. So for the purposes of today's webinar, we're going to focus on what the code's default rules are. You should check your articles and bylaws to see if your organization has already adopted alternative requirements. And if you have, I would flag those for further review or just for a second look. Ask, are the alternative rules allowed by the code? Is this an area where the code does give you flexibility? And then ask yourself, are they workable and desirable for the organization? You might find that the default rule in the code works better for the purposes of your organization. There is a reason why they're the default rule. So that's something that I wanted to flag as well off top. So let's give some legal background. There are a lot of good practical reasons for why nonprofits should have regular, well-run board meetings, but there's also legal reasons for why your nonprofit has to have regular, well-run board meetings. And that's because under DC law, nonprofit directors are what we call fiduciaries of the nonprofit organizations that they serve. That means that directors owe a heightened legal duty of care and of loyalty to their organization. And if we dive down a little bit, that duty of care means that directors must act in good faith and in a way that they reasonably believe is in the best interest of the nonprofit. They should stay informed of matters and issues relevant to the nonprofit, and they should exercise independent judgment. To exercise their duty of care, directors must meet regularly as a group to discuss the affairs of the organization and to take necessary votes and actions. So under this framework, board meetings are one of the key venues for where the directors get together, they share information, exchange information, they debate issues, they engage with the issues affecting the nonprofit, and they take necessary actions. That's why, from a legal perspective, it's really important that you're conducting your board meetings properly. So let's get to our first big substantive question, which is how often should the board meet? And in a way, this has the most unsatisfying answer because there is no one-size-fits-all answer. The frequency of your meetings will generally depend on the needs of your organization. You have to meet often enough to keep directors informed and engaged, and you have to meet in order to vote on pending corporate actions. So there are some demand side requirements for how often you're going to meet. The existence of board committees, and especially, for example, an executive committee, may allow the board to act in between full board meetings. So, for those who don't know, an executive committee is a committee of the board consisting only of board members. So it's kind of like a subset of the board that's empowered to vote and to make decisions, generally sort of day-to-day management decisions on behalf of the whole board. So you're sort of delegating a subset of decision-making and voting authority to a smaller, more nimble, group of directors, instead of having everything have to come before the full board. If that's the structure that you have, and we have a webinar on executive committees, if you have an executive committee, you might not need to have as many full board meetings as an organization without an executive committee. But you still need to have regular meetings because all the directors do need to keep up to speed about what's going on. And there are some corporate actions that the executive committee cannot or should not take on its own. Finally, your bylaws may already specify the frequency of your meetings and or set specific dates for your meetings, especially your annual meeting. So the founders or the incorporators of your organization might have already thought this through, and it might already be in your bylaws or articles. Generally, the board can hold two types of meetings. One we call regular meetings. These are held at regular intervals and are scheduled in advance by the board and or your governing documents. So you might have monthly meetings, quarterly meetings. Your annual meeting is something that's generally scheduled in advance. And then we have special meetings, which are non-regularly scheduled meetings of the board. They can pop up maybe in response to a specific issue, or you just want to have a meeting, but these are the non-regularly scheduled meetings of the board. And the special meetings are where some of the technical requirements are most relevant. Okay, so let's get to another question. Who can call a board meeting? So when we're talking about your regular meetings, those are set by the organization's governing documents in advance, or they can be set by a resolution of the board, for example, at the beginning of the calendar year. You don't need to call each regular meeting individually if you set them in advance. On the other hand, per the DC Nonprofit Code, special meetings can be called by either the chair of the board, a resolution of the board, the highest ranking officer of the corporation, so like that could be your CEO, or 20% of the directors in office. So the idea here is that you don't want anyone to be able to call a special meeting at any time. You want to have some controls over it, or else the board's going to be dragged into, maybe a unreasonable or unmanageable number of meetings throughout the year. Your articles and bylaws may provide for alternative procedures when it comes to special meetings. And this is actually one area where we at the Pro Bono Center recommend something a little bit different from the DC Nonprofit Code. In our default bylaws, we allow any two directors working together to call a special meeting. That's a little bit more flexible than what's in the Nonprofit Code. You can see there they have a 20% threshold. We bring it down to just two directors putting their heads together, saying we need to have a meeting. They can call a meeting. But that's up to you. This is an area where you have some flexibility. Okay, so let's talk about meeting notice. Per the Nonprofit Code, a nonprofit must give directors notice of board meetings, and as a practical matter, actions and votes taken at a meeting might be questioned or deemed invalid if proper notice was not given to all the directors. If we want to be extra cynical about this, you don't want a faction of the board going off, having secret meetings, voting and excluding other members of the board. This is really the reason that we have these notice requirements. So for regular meetings, separate notice is not required because, as we already mentioned, you can pre-schedule these at the beginning of the year. So one notice is at the beginning of the year with the date, time, and place of all regularly scheduled meetings is sufficient as notice. So for example, you can say that the board will meet at 5 p.m. at the nonprofit's office on the first Monday of the month. That satisfies your notice requirements for your regular meetings. When it comes to your special meetings, unless your bylaws provide for a shorter or longer period, the default rule is that you must provide at least 2 days notice for a special meeting. Okay, so how do we give that notice? The code has a default rule. A nonprofit must provide notice in the form of a record. And that means one of two things. It means you can give notice in a tangible form, like a letter or a fax, or what's much more common now is that you can give notice through electronic methods that can be saved and retrieved in a perceivable form, such as an email, a text message, a voicemail. You have a lot of options. No like disappearing Snapchats, that probably wouldn't work, but things that can be saved and retrieved at a later date are fine. So that means that oral notice, so just telling people about a meeting in person or calling people over the telephone, would not be proper because these methods do not create a copy of the message that the recipient can retrieve and review at a later time. But then we have another area of flexibility. If you want, this is just a default rule, your articles in an incorporation or your bylaws can affirmatively allow for oral notice. So another area where you have some flexibility, although for me, when you think about it, I think the default rule makes a lot of sense. You want a physical record of the notice that you're giving to directors, because then if down the line a director says, oh, I never got notice, I didn't know that the meeting was happening, I would have voted against everything. You can point to something tangible and physical and say, no, look, we sent you the email or we sent you the fax or whatever. If you're allowing people to give notice over the phone, it could be really messy down the line when you're trying to figure out who actually received notice. So in this case, I would recommend going with the default rule, requiring notice in the form of a record. Okay, how do we know if we've provided notice in the required time frame? So as we mentioned, the default rule is 2 days for all special meetings. Your nonprofit may have more or less days. So for tangible notice, for our letters and our faxes, it's considered effective on the earliest of when the director actually receives the notice, when the notice arrives at the director's residence or usual place of business, 5 days after a mailed notice is deposited in the U.S. mail, or the date shown on a return receipt from the U.S. mail or a delivery service. So you can see that these rules were written back in the day when a lot of correspondence was happening through the mail, and it was very important and pertinent to figure out when a person, quote unquote, received the notice for the purposes of counting this 2-day requirement, for example. Nowadays, you're probably more interested in the next point, which is that for electronic communications, notice is considered effective when the communication is received by the director's system in a form capable of being processed, of being opened. It does not have to actually be read for the notice to be effective. However, a notice sent to the wrong email address or attached to an email on a corrupted file is not effective notice, even if it's successfully sent by email. So the takeaway there is that if you have, for example, a 2-day notice window, the notice is effective once your email shows up in the director's inbox. They don't actually have to read it for you to have satisfied that 2-day window requirement. Continuing on, the nonprofit may use any or all of the above notice methods. The notice does not have to be the same for all directors or in a format that the director requested. The notice also need not describe the purposes of the regular or special meeting unless required by the Articles of Incorporation or bylaws. So one example of when this might be required is in our default bylaws, we say that if you're going to amend the bylaws at a meeting, you have to provide notice that that's what you're going to do and have language describing what the amendment is going to be before the meeting. So your bylaws might, identify specific issues where you want to give people not just notice that a meeting is happening, but notice of substantively what the meeting is going to be about. But the default rule is that you don't have to give that kind of notice about what the actual substance of the meeting is going to be about. Now, directors can waive the notice requirement by either submitting a signed written waiver before or after the meeting, appearing at the meeting without promptly raising an objection to the notice issue, or showing up at the meeting and participating, even if they do object to the lack of notice. We have this here as a kind of escape valve for when you need to have an emergency meeting. That's the most relevant time when this is going to crop up. Let's say today at 5 p.m., someone learns of an important pressing issue that's going to affect the nonprofit, and you want everyone to come together on the phone at 7 p.m. for a special meeting to talk the issue over. you can't give people 2 days of notice for that special meeting. So in that case, you're going to try to get as many people on the phone and participating as possible. That waives the notice requirement for them. And for the folks who don't show up, you can get a written waiver of the notice requirement from them so that they can't come back to you later and say, oh, I didn't get notice of the meeting. I didn't have enough time to clear my calendar and come, and kind of question what happened at the meeting. So the waiver provisions are pretty important in those situations. Okay, let's talk about who has to attend. A quorum of directors must be present for the board to actually take action at a meeting. Unless your articles or bylaws indicate otherwise, a majority, or 50% or over, of the board's directors must be present in order to establish your quorum. The code allows nonprofits to set a quorum that's less than 50% in your articles or bylaws, but you cannot set it at less than either a third of the board members or less than 2 directors. So there's a floor. Now here's one situation where the code gives you some flexibility, but creates some thresholds and some boundaries. So you can go below 50%, but not less than a third or less than 2. And of course, you can choose to go over 50% for your quorum requirement. So definitely check your bylaws to see what your quorum requirement's at. Unless your organization's bylaws provide otherwise, you can be present at a meeting even if you're not physically at the meeting, as long as you can hear all the other directors at the same time and participate in the meeting. For example, you're able to ask questions, you're able to speak, provide input, and there's a mechanism there that allows you to vote along with everyone else. So this can be achieved through a properly run conference call or video conferencing software. This is the default rule in the code, which is good. We still recommend that people put a provision in their bylaws affirmatively allowing meetings to be held via teleconference or video conference, just to make it clear to everyone, get everyone on the same page that this is an acceptable way of conducting a meeting, is to have some or all of the participants phoning in. If not enough directors show up at the meeting to have a quorum, try to reach them by phone or video conference so they can still be present for the meeting, or consider rescheduling the meeting. Technically, you can have discussion at a meeting without a quorum, but no actions can be taken. But something that we like to emphasize is that everyone who eventually votes for the action should have been present for the initial discussion. So if you're having a discussion at one meeting where there's no quorum, and then folks are voting at the next meeting, there are necessarily going to be directors at that second meeting who weren't there for the initial discussion. There's going to be a disconnect. And those folks are not going to be voting in the same informed way, and they will not have been able to have the opportunity to kind of guide the conversation and voice their concerns. So we recommend as a best practice to save the substantive discussion around an issue for when you have the quorum that you need to actually vote on the issue. Okay, and that gets us to voting. So normally, if a quorum is present at the meeting, the affirmative vote of a majority of the directors present, so 50% or more of the folks in the room, is sufficient for the board to take action. However, the nonprofit code and an organization's bylaws may require that a resolution be adopted by a majority or more of all the directors then in office. For example, when you're appointing directors to board committees, that is an area where you want to have a majority of vote of all the directors in office, not just the directors who have showed up for a particular meeting and have made the quorum. The idea here is that board committees, you're really delegating the duties of the whole board to kind of a smaller subset of the board. You want everyone to be on board with that delegation. Same thing with amending the bylaws. That's a major decision that affects the functioning of the board itself, and so you want to make sure that at least a majority of the full board is supportive of that decision before you go forward with votes like that. So here are some examples. If your board has 15 members and 9 of them are at a meeting, a quorum is present since more than 50% of the directors, so 8 or more, are in attendance. So that's good. You can vote on most matters. A vote of 5 directors, a majority of those present, 5 out of 9, normally would be sufficient to take action. However, if the matter requires a majority vote of all directors, 8 must vote in favor for it to pass. In other words, almost all of the directors present, 8 out of 9, at this particular meeting would have to vote to pass that kind of vote. If the matter requires a 2/3 vote of all directors, then not enough directors are present at this meeting to take action, since you would need a minimum of 10 out of 15 votes to pass, and you only have 9 people in the room. So that's how this can break down. So majority vote, okay for most matters, but your articles, bylaws, or the DC code might identify specific votes that require more than 50% of the quorum. Something we want to emphasize for sure is that no proxy voting is allowed on DC nonprofit boards. Directors must be present to vote. So, I can't make the meeting tonight. I tell another director, hey, I saw this item on the agenda. Can you just vote yes on that item for me? Not allowed. Under DC law, directors must be present to vote, and it kind of goes back to that idea of your fiduciary duties. You have to be in the room. You have to be receiving all the information that's being exchanged. You should be active in the debate. You can't just tell someone ahead of time what you're going to vote. There's a sort of carve out here, and it's something called unanimous written consent. DC law allows you to use unanimous written consent to take action outside of a board meeting. So that means that the action has to be unanimously agreed to by all, and that means all, 100% of the directors currently in office, and a written consent to the action is submitted by each and every director. So this is a little mechanism that we have under DC law that allows you to kind of take action via email, for example, for some matters that are just so uncontroversial that there's no point in getting everyone together in the room to kind of bat it around. If you have 100% support from the outset, then we'll let it slide. But this isn't the same thing as a proxy vote. You need all of the directors to opt in, and you need a written consent from each of them. So if you want to act outside of a board meeting, this is your option, unanimous written consent. You can't vote remotely at a board meeting otherwise. Okay, another topic is meeting in executive session. So a board is entitled to meet in what we call executive session. These are board meetings or portions of board meetings where only the directors meet. Staff and other attendees are excluded from the executive session. Sometimes we call this a closed meeting or an in-camera session. Select staff or professional advisors may be invited to join on a case-by-case basis. So oftentimes you'll invite the CEO to also sit in on your executive session meeting. The board can vote and take actions during an executive session. So just because you're meeting in a closed session or an executive session doesn't mean that you can't take votes. You can totally take votes. One thing that we want to emphasize is that you must still take minutes of your executive session meetings. You segregate those minutes in a separate document to maintain the confidentiality of what was discussed. So the way this would usually look is, let's say you have a normal open board meeting, you take minutes of that meeting, and then maybe at the end, the board goes into executive session. So on the regular board meetings, you just have a note, and then the board went into executive session. And then in a whole totally separate document, you start the minutes for the executive session. So there's no cross-contamination. That way, if people request to see the minutes of the normal meeting, they don't see the minutes of the executive session meeting. So why all this secrecy? So the purposes of executive session. The first and most important one, I think, is confidentiality. It creates a confidential venue for discussing sensitive or confidential topics, like your audit, or pending or possible legal matters, personnel issues. It encourages board members to have candid conversations with each other. The idea is that if it's just the board, people might be a little bit more straightforward or might be more willing to address controversial or unpopular topics. It allows for independent board oversight because you're making decisions without the influence of staff, the CEO, your donors, whoever else might be at the meeting. Since you kick them out, you're able to really bat the issue around as a board. It allows for board development and self-management. Sometimes it's useful to create a board-only space. It allows for the members to get to know each other better and to discuss and resolve issues relating to the board itself. If you want to discuss, board performance issues, you might want to not do that in front of the rest of the staff. And finally, it can help build the board-CEO relationship. So in sessions where the CEO is also invited, you can have candid and confidential conversations between the CEO and the board. It allows you to really kind of mentor the CEO, allows the CEO to be transparent and candid about their concerns, address staff issues. So generally speaking, we think that executive session is often a useful or appropriate venue for the board to meet in. There is certainly a risk of overusing executive sessions. If you do that, you're going to have some issues with the transparency of your board meetings, if everything's being kind of done in secret. You might also not be getting all the voices and perspectives that you want at your board meetings in the meeting if you're only meeting with the directors. So there's a balance there, but there are definitely situations when meeting in an executive session is the right way to go. Okay, so let's talk about preparing for your board meetings. Part of the director's duty is to prepare for the meetings, which includes reading materials sent in advance and familiarizing themselves with the issues that will be discussed. This helps the meeting run more smoothly. It cuts down on the length of meetings, so preparation is key. How to best prepare for board meetings. You want to send your materials, including an agenda, at least a few days before the meeting, so that directors do not hear about an issue for the first time at the meeting. Definitely a best practice. For any important motion, resolution, or amendment to the organization's bylaws, include copies of the exact wording in advance. If people get familiar with the wording, they're in a better position to comment on the wording and to suggest alternatives. Send reports, committee reports, for example, and financial information beforehand. Another thing to send beforehand. And if a controversial decision must be taken, it could be a good idea for the chair to discuss the issue with board members before the meeting. So a little bit more about conducting your meetings. The articles of incorporation or your bylaws should specify who is the presiding officer at the meeting. This is generally the role of the president or the chair, depending on what you call this person, unless the bylaws provide otherwise. So the role of the chair specifically is to ensure that the meetings are productive, running smoothly, and running on time. They're responsible for setting the agenda for each meeting. They solicit input from staff, committees, and other relevant parties on the agenda. And then for meeting procedure, you don't need to use Robert's Rules of Order or formal parliamentary procedure. It's okay to have more simple and streamlined and practical rules as long as you apply them consistently. So if you're not using Robert's Rules and you have your own procedure for making a motion or adding something to the agenda, it's important that all the directors know how to do that. If you only have a subset of directors who know how to do that, that kind of imbalance is going to cause trouble down the line. So don't have to use Robert's Rules, but make sure that everyone knows the rules. That's the takeaway here. Here's a sample agenda for what your meetings might look like. You might start with the chair calling the meeting, establishing the quorum. You definitely want to introduce any new members to the board or special attendees. Especially with larger boards, you'd be surprised that people might not recognize or know each other, and you don't want people feeling like there are strangers in the room, because that's going to dampen the conversation and make the meeting less effective. So make sure that everyone knows everyone in the room. An important function is to review and approve the meeting minutes from the last meeting. And then you might want to go into your reports, report from the executive director, from the chair. Definitely at some point want to have a financial report and to review the financial situation of the organization. If you have committees, this would be a good time for committee reports. Then the way a lot of nonprofits structure their meetings is to do an old business, new business kind of distinction. So old business are items that were tabled or unresolved from past meetings, items that were sent to committee, for a little bit more work or exploration. So if you have items like that, bring them back, close the loop, take a vote if appropriate on those old items, and then the introduction of new business. I put here under 7, maybe some time for strategic discussion items or brainstorming. A trend right now is to make sure that meetings aren't just all about information downloading and sharing. It should be really also a time for strategic planning, for having kind of critical discussions or visioning sessions with the board to help you set the direction of the organization. Some organizations do a practice where they allow the director or other board members to talk about what's sort of keeping them up at night, what their sort of major anxieties or concerns are. You can sort of play around with how you want to play with that, but it is a really good idea to make sure that your board meetings have a strategic aspect to them and that they're not just this very sort of formulaic downloading of information and reports with maybe limited discussion and engagement. And then you can adjourn the meeting. So that's a sample agenda. The way that you structure agenda can vary. There's something that people are doing called a consent agenda. So if there are items on your agenda like approving the minutes and maybe the executive director's report or a very simple, straightforward vote, you can kind of bundle all of those items into one agenda item and just have a straight up vote, yes or no, to approve that package of items, and that gets it out of the way, and then it leaves more space and time for the more substantive or more strategic discussions. So that is something that folks can play around with. But if there's one big takeaway, it's to make sure that you set a clear agenda at the beginning of your meeting to help you run your meeting and definitely keep your meetings on time. And that's it for sort of our structured slides. If folks have questions, there is a question field in GoToWebinar that you can type in questions on, and I can see them. Let's see if we have any out there at the moment. Okay, so we have a question here. Is there an ideal number of directors on the board of directors? The answer is it depends. It depends on the needs of your organization and kind of the age of your organization. So smaller or newly formed nonprofits can have a hard time recruiting an initial board and growing their board initially. Usually it's more based on personal relationships between the founder or the initial board members. So, those organizations tend to have smaller boards. And it kind of makes sense because, especially early on and with smaller boards, you tend to be a little bit more of a working board. The board is really actively engaged in more of the managerial side of what's going on with the organization. And so you kind of don't want too many cooks in the kitchen when everyone's being very involved in the day-to-day activities. As organizations get more mature, you can grow the size of your board, and the board can take a more strategic orientation, play a stronger oversight role, and leave a lot of the day-to-day managerial functions to staff that the organization can hire as it grows and as it becomes more sophisticated. So there's no ideal number. You can definitely have too many members on your board, making it very clunky. If your board is too large, a lot of folks will break off a lot of that day-to-day managerial stuff into an executive committee, for example. But then it sort of begs the question of why you have so many people on the board in the first place if they're not really engaging with the day-to-day decision-making of the organization. Maybe you just want to slim down your board. If you want people to be involved, you can create advisory committees or other ways of getting people's input in without actually having them being on the board itself. So if I see a 24-person board or something, that's sort of a red flag for me that it might be too big. And another recommendation is to make sure or try to have an odd number of members on your board. Another question, will you be sending the PowerPoint slides? Yes. If you want a copy of the slides in the GoToWebinar client, you'll see a tab that says handouts. You can download the slides right from there. If for some reason you've missed them, or if you're listening to this presentation after the fact, we're going to post this presentation on our website, lawhelp.org/dc/CED, and the slides will be attached to the audio file there. What are the rules for the regular board meeting if you cancel a regularly scheduled board meeting? Who and when should folks be informed? So your articles and bylaws might address this specifically, but if you're canceling a regularly scheduled board meeting and you're rescheduling it, treat that as a special meeting and use the same kind of notice rules, because it no longer falls under the provision allowing for no special notice for regular board meetings. It becomes an irregular board meeting. So, if you have a 2-day notice requirement to the directors, use that as your notice requirement, or hope that people waive the notice requirement, but would use your special meeting rules there. How to propose and vote on a resolution. So we can, we don't really have sample language for board resolutions, and they can sort of depend on the needs of the organization. So that's kind of a hard one to talk about on the webinar. You can definitely find sample resolutions floating around online. It's a little fact specific. So if there's a specific kind of resolution that your organization is looking to pass and you have questions about that resolution, feel free to reach out to me via email afterwards and we can talk about what those resolutions might look like. Let's see here. Any other questions? Does the DC Bar Pro Bono Center offer one-on-one calls and consultations to developing or startup nonprofits? Yes, we do. We have a lot of resources for startup organizations. I talk to startup organizations, and other attorneys in our office do all the time. We have a monthly drop-in legal clinic that you don't have to pre-register for. You can just show up and meet one-on-one with a lawyer about any legal issue affecting your organization, and that can include nonprofit startups that have questions. So if you want the dates for those clinics, again, on our website, lawhelp.org/dc/CED, look for our small business event calendar, and you'll see those legal clinics listed there. And we do also match startup organizations with attorneys for ongoing legal support. They can help you draft bylaws, file your 1023, but we want you to have a business plan in place before we do that. Do you have a sample board orientation package? We do not, but we do have a really great program coming up that can help you with your board orientation process. It's called Board Basics A to Z. It's a one-day it's a one-day kind of, we used to call it a boot camp for nonprofit directors, for kind of long-serving directors, but especially first-time nonprofit directors. We hold it a couple times a year. The next one is going to be on January 26th, Saturday, January 26th. And you will find information about that event, again, on lawhelp.org/dc/CED. But again, that's a full day kind of being on a board 101. We cover topics like your fiduciary duties, the role of directors in financial oversight, the role of directors in risk management and purchasing insurance, strategic planning, a lot of issues. So look to the website, and we're currently registering folks for that right now. Another question, do you have a business plan development template? We do not. That's a question that we get asked a lot. We have a podcast on the website about business planning that you might want to check out, and we talk about business planning resources there. There are some resources in the city like SCORE, which is an organization that helps with business planning. DC government has a lot of agencies and programs to help with business planning, but we do not have a template business plan. We're focused more on the legal side of issues. Is there a way to cure an improperly called board meeting? So if you, let's say that you didn't give folks appropriate notice, as we talked about, people can waive the notice requirement just by showing up and not objecting to the lack of notice, or by showing up and participating in the meeting, or they can give you a written waiver of the notice problem. For improperly called board meetings, let's say your bylaws say that it's either the chair or 2 directors are empowered to call board meetings. No one else can do it. And the treasurer, acting alone, called a board meeting. Everyone came, everyone participated, and then you're looking back and you're like, oh wait, that that person didn't have the power to call a board meeting all by themselves. At the next meeting, or through unanimous written consent or through a resolution, you can retroactively approve what happened at that meeting to kind of clear up any ambiguity about the propriety of that meeting. So the board can always look back and retroactively approve at a properly called meeting things that have happened in the past. Another question, are there prerequisites required to enroll in the board boot camp that I just mentioned? No, there are not. So anyone who's interested can come. And let's see. All right, that's all I've got for now. So let's call it a day. Thank you again for attending our webinar. If you have any questions, feel free to email me. My email's right here on the slide, jqu@dcbar.org. And I'll hopefully talk to a lot of you again at our next Board Basics webinar. Thanks, everyone.